Senator Back.
Thank you, Acting Deputy President. Before addressing myself to the Competition and Consumer Legislation Amendment Small Business Access to Justice Bill, I propose to spend some moments on the importance of the Native Title Amendment Indigenous Land Use Agreement Bill, and I also will foreshadow that I will be responding to what I believe to have been a highly inaccurate and cowardly statement by Senator Dastyari about Chevron and its now Managing Director, Mr Hearn. I think it's a disgrace that a person under parliamentary privilege would come in and make the statements he has made, but I will get on to that in a few moments because he is wrong, and this chamber and those listening need to know just how wrong and how dastardly Senator Dastyari has been in that attack on Chevron. Let me go, if I may, because it is directly relevant to the opportunities in small business access, to that associated with the Native Title Amendment Bill that is before us, and I've got to urge everybody in this chamber before we rise and return to our home states and territories that we've got to address this anomaly. It comes about as a result of the fact of a decision of Justice McGlade in the Federal Court in Perth recently, in which he overturned what had been the decision of Justice Bygraves previously in relation to native title claims, and particularly the percentage of native title claimants associated with them. Bygraves had the view that so long as there was greater than 51% of native title claimants, then it was possible to proceed with what is known as an Indigenous Land Use Agreement. Where McGlade has caused the change and has caused the ruction, Acting Deputy President, is that McGlade has effectively required 100% of claimants to be in agreement before anything can proceed. Now, yes, it's got something to do with Adani mine, but by Jove, that's only one of the very few. I learned from my very good colleague, Senator Scullion, that there are some 126 agreements around Australia associated with native title that are affected by this decision and are going to affect the benefits to native title claimants associated with those Indigenous land use agreements, which are themselves, of course, voluntary. They're providing an opportunity for native title groups to use those rights in beneficial ways, particularly in relation to economic development, to provide certainty for all parties doing business on native title land. And if Senator Dastyari and his colleagues, indeed everyone in this chamber, is genuinely interested in ensuring the continued benefit to native title recipients under those ILUAs or ILUAs, then it will be in their greatest interests to make sure we do not rise from this place until we deal with it. There's a bill before the chamber. It will address the concerns that McGlade has raised, and it is incumbent on all of us. And if we fail to, Acting Deputy President, each one of us must go back to those native title groups, including those in the Indigenous areas, as well as the companies with whom they deal, and explain to them why now there is no certainty. I know on a personal basis a colleague who only this week and next week is associated with some negotiations on native title. And this particular person here in the eastern states this week representing the interests of Aboriginal people, and next week in the north of Australia he will be representing the interests of a mining company. An absolutely eminent man of great integrity. But I know that this negotiation is now on hold whilst we deal with this issue. Acting Deputy President, it is the case that a grant that is made under an invalid Indigenous land use agreement will itself be invalid against native title. That's in my state with the Noongar people for whom this particular judgment was made in the Federal Court by Justice McGlade. It will have application right around Australia and, I dare say, the islands adjacent to us. This is of critical importance, and if people really want to do something in the small business space to continue to encourage Aboriginal people under these ILUAs, to continue to encourage other companies to deal with, to participate in and to work for the improvement of people in those communities, it is essential. It is essential that we deal with this Native Title Amendment Indigenous Land Act. I appreciate the fact, Acting Deputy President, that Senator Dastyari has remained in the chamber. I thank you for that. Senator Dastyari made the comment a few moments ago, and if Hansard proves I am wrong, I am willing to be corrected. You made the statement through you, Acting Deputy President, that Chevron had paid no corporate tax in the last couple of years. I can tell you, as a result, perhaps wrongly, Acting Deputy President, did I use a mobile phone in the chamber to check only in the last few minutes with a senior executive of Chevron Australia, who assured me in the last 4 to 5 years that company has paid no less than $4 billion of tax. $4 billion. And if you listen to Senator Dastyari, you would be invited to draw the conclusion that company had paid no tax. That's were the words that were used. No corporate tax paid were your words through you, Acting Deputy President. Senator Dastyari, knowing as he should about the petroleum resource rent tax, since it is a super profits tax after you have met and had reimbursed certain costs, he is making the comment that in the projects with which Chevron is associated, they've paid no PRRT. For heaven's sake, Acting Deputy President, the project at Gorgon on Barrow Island has only got 2 of 3 new LNG trains up and running. The project at Wheatstone hasn't yet commissioned its first one. How in heaven's name could a person who pretends to have the economic knowledge he's got, that Senator Dastyari's got, understand and believe and stand up in this place and draw the inference that this company's paid no PRRT when indeed they haven't yet got to the stage of making a profit? What Senator Dastyari failed to say was that this company, Chevron, which he is so keen to run down, has invested no less than, isn't it amazing, Acting Deputy President? Did I interrupt Senator Dastyari when he was attacking a fine company investing billions of dollars in my home state? No, I offered him the courtesy of silence. But the words that I'm saying are resonating with Senator Dastyari because he's trying to close me down.
Senator Back, resume your seat. Senator Dastyari, you will not use those words in this place, and you will withdraw them.
Sorry, Mr. Secretary, President. Which words? I'm not quite sure what you wanted me to withdraw.
You do know which words you have to withdraw.
Oh, sorry. I'll withdraw any comment. I'm not. I genuinely didn't mean offence.
Senator Back, you have the call.
Thank you, Acting Deputy President. I assure you, Senator Dastyari, no offence was taken. But I do want to place on the record the fact that this company in 2 major projects at Gorgon and Wheatstone have invested or are investing $130 billion US. To put it into perspective in today's dollars, that is a project 15 times the size of the Snowy Mountain scheme, $130 billion US. They will have employed 19,000 people in construction. Over the 40-year life of those 2 projects, they will contribute trillions of dollars to the Australian economy, over 100,000 jobs, billions of dollars in taxes and royalties, and yes, petroleum resource rent tax. They have invested billions of dollars with local small businesses in Western Australia, around Dampier, around Onslow and around the other ports. They have effectively developed the town of Onslow, and whilst comments were made by Senator Dastyari about a person who can't defend himself on projects outside of Australia, I can relate to this chamber, as I have done in the past, the very, very fine occupational health, safety and welfare record of that company. And just finally, in passing, before I go back to address myself to the subject of this discussion today, I should say to you, for those who have concerns about Chevron in the environmental space, Chevron's Gorgon project on Barrow Island is in fact in an A-class reserve. It is by far and away, as a result directly of Chevron's investment and care for the natural environment of Barrow Island, it is by far and away the best managed A-class reserve anywhere, not only on mainland Australia but around the Australian coastline. And I reject totally and thoroughly the assertions made by Senator Dastyari. Let me now turn, if I may, to the bill that is before us and say very, very proudly that the coalition government understands now, always has and always will back small business. We will back it like a Melbourne Cup winner, up the straight, all the way past the finishing line and through to the parade area. Acting Deputy President, I'll tell you why. because it is the engine room of the Australian economy. It employs nearly 5 million Australians in the rural regions, in remote areas of Australia, in suburbs. It employs people at the lower end of the skills level as well as through to highly skilled people. It is the most versatile of all of the employment groups in this country. And I'm very proud to say only in the budget of the last couple of days have we announced yet again a further tax cut for small business, and of course we will see it reduced to some 25%, the company tax rate. And for those who quite rightly say, an enormous number of small businesses are not companies, it is important to record that there is also a 5% tax discount for unincorporated companies, for sole operators, for partnerships. We are continuing. These are the real issues that help small business, the issues that help small businesses encourage further employment of young people and older people in our economy. The tax deduction of being able to write off in the 1 year the $20,000 for assets purchased, and multiples of them, Deputy President, not just one. As a restaurateur, cafe owner said to me when we first introduced this, he said, I can now bring forward by 4 months starting up my new business because I can purchase different equipment to make that operation run, each one up to $20,000, and I can write it off fully in the first year. That restaurant up and running, 14 or 15 staff already. So, acting, at least Deputy President, very, very proud to say what the coalition government is doing and will continue to do. I know, having run small and medium-sized businesses and still being associated, assisting constituents where I am able to in terms of their obligations under BAS statements, and PAYG and paying superannuation, etc. It is the small business person who really does the work for the tax commissioner, fills out the BAS statement at the end of every quarter, makes sure the superannuation commitments are met and paid, ensures, of course, that workers' compensation insurance is paid, public liability insurance is paid. It's no wonder it's so difficult to make a quid in small business. But this government has cut by $4.5 billion red tape, simplifying those processes that I was just speaking about, removing many small businesses, up to 500,000 of them, from the PAYG system. And of course, Deputy President, one which I am very, very minded towards and I think needs enormous support from the Parliament, and that is this employee share scheme. If we can get employees to actually own shares in the business in which they are employed, then of course they have that greater incentive because they themselves are part of the ownership, and I for one will be watching that aspect of it very, very closely. We have seen, of course, only in recent times with the opening up of the China-Australia, the Korea-Australia, the Japan-Australia free trade agreements. The best example of all, of course, is the cherry producer in Tasmania, who has taken his cherry exports from a very, very small proportion now to be a very significant exporter of that horticultural product into the Chinese market, with significant improvement in employment, as I understand it. Perhaps Senator McKim would be more familiar than I and might know. Oh, there you go. We have proof here of the evidence not only of the quality of the product but hopefully the quality of his staff as well, through you, Deputy President, to Senator McKim. But these are the initiatives being taken by this coalition government in the services sector, in the commodities sector, to encourage small business even more. And of course, an ombudsman being appointed, and reference is made to the ombudsman in the bill being proposed by the Labor Party, and I'll speak some more about that particular position, the ombudsman's position. If I do go to it, in fact, it's proposed in the bill to enable the ombudsman to provide assistance, as I understand it, with advising a private litigant on the arguments that might be made and the evidence needed to satisfy a court to grant a no adverse costs order. That of itself sounds all right. The only problem, of course, is to what extent might it compromise an ombudsman who afterwards may have been seen to have given advice to an applicant or to a private litigant, only to find out that that advice is now the subject of a challenge, and indeed we can't really have a circumstance in which the Ombudsman could themselves be the subject of a court action as a result of incorrect or inadequate advice given to a litigant. So there are, I think, difficulties associated with that particular element. But I would applaud the Labor Party in the terms of putting this bill before the chamber. It recognises that they do have an understanding of some of the challenges associated with the issues of small business in Australia, expanding small business. Deputy President, for those of us who have been in business all our lives, we actually don't like the term small business all that much. It suggests that you want to remain small. Well, of course, you don't want to remain small. The whole objective of business is to grow that business and to move perhaps towards medium business, and in so doing to employ more people. And I come back to that employee share scheme. Imagine the scenario as long trusted employees are part of an opportunity to expand a business. And then indeed the next step, not always the best step for a business, not always the best step in my own experience, but nevertheless the opportunity to move into export markets and to be able to develop both your services and or commodities along those lines. But mention is made in this legislation, of course, and I come to the decision of the coalition government in accepting the recommendations of the Harper Review, and that, of course, is the repealing of section 46 of the Competition and Consumer Act, replacing it with a provision that prevents firms with substantial market power from engaging in conduct that has the purpose, effect or likely effect of substantially lessening competition. And I join with Senator Dastyari in the concept of the capacity of a larger company to be able to use its market power, market strength, to be able to dominate a small business. I have no difficulty with that argument. He just chose the wrong example, in my humble opinion. I will give you an example of some of the big retailers who will proudly announce to the retail market that they're going to undertake a huge discount of some product, only then to go back to the farmer, the supplier, the horticulturalist and say, oh, by the way, we're undertaking now a big discount on milk or a big discount on chicken or a big discount on some other product, be it almonds or whatever, and by the way, we're going to pay for most of it by reducing the payment to you in that scenario. That is abuse of market power. It places the small business in a circumstance where they cannot negotiate their way out of that. They are locked into supply and, of course, they have no alternative. So there are definitely circumstances in which we've got to make sure that we ensure that big business does not have that unfair competitive advantage. And of course, other legislation that we have introduced in this same space, the Fair Work Amendment, penalty rates exemption for small business, which we introduced into this parliament in 2015. And of course, one that again is directed at protecting the interests of small business and indeed protecting the interests of employees in small business. We have seen, of course, the involvement of the ACCC, in which they released only in November of last year their report going to the whole concept of unfair trading relationships between large and small business, particularly in those in which small business is afterwards forced, in a sense, to sign contracts, or at least influenced to sign contracts. And under the provisions of ACCC, which the government accepted, of course, we now know that a small business can challenge a term in a standard form contract, which is also a small business contract, on the basis that it is unfair. Now, big business weren't happy with us. They were not happy with us. They lobbied very, very hard against us. But the decision that was taken, of course, was to ensure the protection of small business. Those organisations, as we all know, most small business people, they are their own accountant, they are their own person associated with marketing, they are their own person associated with sales. As I said earlier, at the end of every quarter, they are the person sitting down who's trying to work out the BAS statement, to try and work out revenue expenditure, make sure they get superannuation liabilities paid, etc., etc. They are not the sort of organisation that's got huge teams of lawyers and accountants and others. And so it is the Coalition Deputy President who will continue to support small business, continue to support small business by way of entrepreneurship, by way of innovation, by way of start-up, by way particularly of protecting small business when it comes to competition with big business and indeed with big unions. So whilst the Labor Party's bill is there to be debated, it does miss most of the elements important to small business.
Thank you, Senator Back.